All right, good morning. I'm going to call the docket. When you hear your name, please say present or here. Bryce Carroll. Bryce Christopher Carroll, sanctions court hearing. John Davis. Michael Davis. Alejandra Mota. Alejandra Mota. Jimmy Booker. Wendy Johnson. Randy Young. You're trying to get my attention. Maybe where?
Judge, I spoke to his bondman this morning, and Mr. Young is in transit. He's coming from Louisiana and we're a little bit late.
Landon Watson. Mr. Watson too. Yeah, Landon Watson. Tyler McInnis. JC White. Mr. White should be appearing via Zoom along with Mr. Brian Schmidt. I'll recall that case. Javier Zarate. See Mr. Zarate. Michael Chitty. Sandra Fletcher. Brian Classen.
Present.
I'm sorry, I said Brian. It's Ryan. I'm sorry. Tiffany Cooey. Joshua Martin. Mary Robinson. Isaiah Rosser. George Valderrama.
Your Honor, we have been in contact with Mr. Valderrama. He's coming to Boulder City. I'll check with my staff before we are in.
William Laney.
Present.
Marcos Hernandez. He's not due here till 9:30, so I can recall his case. And then Kenneth Nash and Miranda Boaz are at 11. All right, is there anyone who's present and you've not heard your name called? All right, counsel, do we have anyone that's ready? Dwight?
Your Honor, can I take one matter really quickly? I'm representing Mr. Classen. We filed waivers on those. These cases were filed at large. We've made arrangements. I believe the state and I are going to be asking the magistrate to issue a PR bond on the driving while intoxicated case. He's actually got a recommended bond on the other case. We were hoping if we could go ahead, since we made arrangements with Mr. Nicholas to post the bond. I don't know if there's any way we can get him out to the jail quickly for being the magistrate before the magistrate leaves.
We can go ahead and call the case now. You're representing him on the DWI misdemeanor.
Judge was also prior indicted PCS PG1, I believe, one of the four CR 21.
30.
Can you look that up for me and give me that cause number? I don't have.
This judge, it is CR 21-00331. It is possession of controlled substance. One programs.
And has that one been, that one's been adopted? Has that one been arraigned?
No, sir, they have not. We filed, actually, we went ahead and filed waivers this morning, so they'll probably come to you.
Okay,
And
well-
set for January 14th, I think is the date that this paper had given.
January 14th. All right, and so we need to arraign him. Did you file waivers on the class B misdemeanor also?
Yes, sir, I did.
Okay. All right, so, and that's your recollection, Mr. Abraham, is that they're already set for pretrial on January 14th,
24th, Your Honor.
24th? Yeah, I don't know. All right, Mr. White, if you'll fill out notice of appearances for Mr. Classen. Court will find that waivers of arraignment have been filed. The court's not reviewed those. Assuming those are in correct form with acknowledgement and dates, then the court will approve those and we'll set Mr. Classen for pretrial January 24th in both CR 2259, Class B misdemeanor driving while intoxicated, and CR 21331, possession of controlled substance 1 to 4, third-degree felony. Yeah. So we'll go ahead and have Deputy Everett take Mr. Classen into custody and then go ahead and arrange transport, Mr. White.
Thank you.
We get it. Comes in. Mr. Harden, are you ready?
Yes, Your Honor. That's right.
You may. Get the Brown.
I was just retained on State versus John Robert Davis.
John Robert.
He's pressing in the courtroom.
Okay.
And
Mr. Davis, if you'll come forward, CR 2155. Just stay right there, Mr. Davis, right there at that podium.
his wife just passed away, and Southern States agreed to reset this to next month, and I've got to have time to get the discovery and see where we are.
Okay. All right, this is CR 2155 State versus John Robert Davis. We are set for status to hire attorney. Mr. Hardman is here and has been retained by Mr. Davis. We'll recognize Mr. Hardman as counsel of record for Mr. Davis, and we will set this matter for, let's set it for the contested docket on January 26th.
That's fine, Judge.
Okay. All right, if you'll, let's see here. 26, that will be at 23, that'll be at 9 a.m. All right, if you have your client sign there where it says defendant, and then give him the yellow copy, and leave us the white, and he'll be free to go. Is that all you have, Mr. Jordan?
That is Maddie.
Yes, thank you, sir. Good to see you.
Have a Merry Christmas.
You too. Have any other attorneys? Mr. Harden, Mr. Woodward was getting.
We just added new discovery, so we should have.
Thank you, appreciate it. All right.
You think Ms. Mota may be in our jail? She's not there. Mr. Booker, CR 22239. All right, Mr. Booker, how are you this morning? All right, Mr. Booker, we were set for pretrial hearing today. The court finds that you have filed some pretrial motion to dismiss. Is that correct? So what we'll do is we'll set that for hearing. That'll be a chance for you to argue your motions. We'll set that on January 26th, unless you have an objection to that date. Okay,
January 26th.
January 26th, we're gonna fill out a notice of appearance. That gives the state's received Mr. Booker's motion to dismiss, I'm assuming.
Yes, sir.
Okay. Were there any other motions filed, Mr. Booker, other than the motion to dismiss?
Well, basically, I mentioned in the motion to dismiss to suppress any evidence that was not mentioned in the applicant, rule 201.
Okay, so if the state will just review to see if there's any sufficient motion to suppress raised, then we'll take up that issue on that date as well.
Thank you.
And we need to discuss, give you some notice on it now, on the
We'll discuss everything on the motion to suppress or dismiss on the 26th. That's where you'll make your legal arguments and the state will have a chance to make theirs.
All right. Thank you very much.
All right, we'll see you on the 26th, Mr. Booker.
We did.
Wendy Johnson. Good morning, Ms. Johnson. Ms. Burns went to get me a copy of your probation extension. As soon as I get that, we'll talk about that and get you out of here, okay?
Okay, because I did, I did pay about $500 and some yesterday.
Mhm.
And I did have, I've been sick, and had to, send my check went down, I've had to buy stuff out of my own pocket, so I owe like $355 yet. I do have an inheritance coming in that I should be able to get next week. But I hopefully they haven't paid off by the first.
Okay, yeah, let her give me the information. I don't know anything about your case right now. Oh, got the wrong. Is that what Karen did? All right, Ms. Johnson, so you're looking to extend your community supervision for an additional 3 months so that you can finish paying
Yeah,
off?
but I should have it paid way before.
Way before then?
But yes, sir,
Okay,
and I know that $355 I might get paid.
okay. So Ms. Johnson, just raise your right hand. I'm gonna place you under oath. Ms. Johnson, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So if you got,
I do.
all right, you can lower your hand. All right, Ms. Johnson, on this issue of extending your community supervision, you've told me the reasons. Is there anyone who's threatened you, forced you,
No.
pressured you to make
No.
you, let me finish, so you'll know what my question is, all right? Has anyone threatened, forced, or pressured you to make you feel like you had to enter into an agreement to extend your probation? Okay, you're doing this because this
I'm
is,
doing this because I don't want to go to jail.
okay,
I don't
right,
wanna pay
well-
up and Free the county.
I understand, so, but you're asking the court to extend so that you can get into compliance and finish off all of your
Yes.
obligations before you expire, is that correct?
Yes, sir.
Okay. All right, the court will grant the amendment to the conditions of community supervision to extend Miss Wendy Deanne Johnson's probation for an additional 3 months, which is set to begin on December 18th and expire on March 17th, 2023. All right, the court will find that the additional probation fees and your analysis fees will be waived for Miss Johnson based on her circumstances and this extension. All right, Miss Johnson, come over here and see the probation officers. They'll get you a copy and you're free to go. I wonder if Mr. Bryce went to the wrong courtroom or it's not like him not to be here. Yeah, if you look that up, it's not like him not to be here. Even when he doesn't do what he's supposed to do, he still shows up. Let me see who I have on this one here. All right, court's going to bring in Mr. Brian Schmidt and his client, Mr. J.C. White. Good morning, Mr. Schmidt.
Good morning, Your Honor.
I brought your client in. He's not connected yet.
DSW, Your Honor.
Sir,
Oh, is it a DSW email? You said you're bringing them in?
it just says J.C. on my Zoom.
Okay, they probably.
It's not connected to audio and this video is not turned on.
They've never used Zoom, Judge. I was explaining to them how to do it. Hopefully it's. They said it was waiting for proceedings to start, so they were somewhere in there.
Yeah, they're in the waiting room, so they definitely saw that. Okay, we'll wait for just a second for Mr. There he is. I can hear him now. Mr. White, can you hear me? He has his audio on. We're just working on video. Is Landon Watson here? Okay. All right. Mr. Platten is going to be appearing via Zoom. As soon as I conclude this hearing, we'll start.
Just start video.
There you go. Okay. All right, Mr. White, can you see and hear me okay? This is Judge Chris Martin. Mr. White. Should be able to hear me, Mr. Schmidt.
Seems like it's freezing up.
All right, Mr. Schmidt, let's go ahead and make an announcement. This is cause number CR 22-298, CR 22-310, State versus J.C. White. I have a docket call on the evading arrest, and I have pretrial on the driving while intoxicated Class B.
And Judge, actually, they're both from the same incident. It's my understanding that we reset pretrial last month because I was out in quite a bit of October for me to review the discovery on both cases, and so I thought we'd reset pretrial for both of them today, as I had not reviewed the discovery.
That could very well be the case.
And I think I only put one cause number on the reset notice, which is why, Judge. But nonetheless, I have no contested pretrial. I have reviewed the discovery, both audio, visual, and the written discovery, and I have no contested pretrial issues.
Okay, very well. Court will then place Mr. White on the docket for docket call, and we'll set this in January. Do you have any conflicts with January 24th?
I do not, Your Honor.
All right, so we'll place Mr. White on January 24th, and that will be at 9 a.m. I'm not sure what courtroom will be in, Mr. Schmidt, but I'll keep you advised.
I understand, Your Honor.
And on the notice of appearance, obviously Mr. White's not here. I understand that Mr. White is ill and the court has granted him the ability to appear via Zoom. So I'm not able to give him a written notice of appearance, and the court will not mail him one either. Court's going to render here in open court the notice of appearance where he's to appear on January 24th at 9 a.m. in both causes.
Thank you, Judge. I'm assuming he can hear you, but I'm going to call him as soon as we get off the feed.
If you'll do so, I've not been able to get him to acknowledge whether he can hear me or see me. So I can see him. So that suffices for the court, but I'll just convey that notice through you.
Very good.
We'll go with that. If there's nothing further, then we'll be adjourned in this case.
Thanks so much, Your Honor.
You're welcome. Thank you, Mr. Schmidt.
All right, bye-bye.
All right, Mr. Watson. Come on up here to this podium. We tilt this just a little bit that way so we can see the podium. No, yeah, turn it to the right. There we go, right there, perfect. Good morning, Mr. Platten. Can you see and hear me okay?
Yes, I thought that I had unmuted it a moment ago.
That's okay. All right, this is, let me flip over here. This is cause number CR 18-113, State versus Landon J. Watson. Court notes that we already have Mr. Watson set for the evidentiary docket on January 26th. I think today was just going to be a status on the motion to see if there was any issues or agreements between the state and the defense.
I think we're close to getting this worked out, Your Honor, just trying to finalize a few of the last things. And we should have this taken care of by the next hearing.
Okay. All right, then the court has already set Mr. Watson for evidentiary docket on January 26th. If there's no agreement on that date, then the court will go forward with a contested hearing.
Thank you, Your Honor.
All right, thank you, Mr. Platt. Mr. Watson, you're free to go.
Yes, Judge. Bye.
That's gross here. Okay.
Have a good day, Your Honor.
Thank you, Mr. Platt. Sorry, yes, sir. The time to do the interpreter. Who has that one? Where's the interpreter? Let's put it right here. Mr. Manning, are you ready on Marcus Hernandez?
Yes, Judge, my understanding is that he was picked up by ICE and is no longer in custody.
Oh,
I have been able to reach him or contact him, and the limited information I was given due to the language barrier. And so that is my understanding is based on my conversation with the Dane County jail, he was picked up by ICE on the ICE hold that he previously had.
all right, thank you, Mr. Manning. All right, so I guess we're gonna need some kind of confirmation of that, and then the state's gonna let me know what you want to do with your case.
Yes, sir.
So we'll reset Marcos Hernandez for status of prosecution. We'll set that on January 24th. You think that gives you enough time, Mr. Woodwide, to?
I believe we can look into it, Your Honor. Yes, sir.
Okay. All right, I'm gonna bring in Miss Dave Villiers and let her know, so she knows she's free to go.
Good morning.
Good morning, Maria. How are you?
I'm doing very well, Your Honor. Happy
Right.
to be with you today.
Good. Well, thank you for being here. I've got good news and bad news. Which one do you want first?
Both at the same time.
Both at the same time. I don't know if I can say both at the same time. Well, I guess we'll go with the bad news. Mr. Hernandez is not here today. Mr. Manning, his attorney, has indicated to the court that it was reported to him that Mr. Hernandez was picked up by immigrations and custom enforcement and possibly deported. So we're going to look into that. So we won't be having a hearing today. That's the bad news. Good news is the rest of your time, you're free to do what you want to do.
There you go. And I'm pretty busy, so I'm very grateful for that, Your Honor.
All
And I
right.
take this opportunity to wish you the best during these December celebrations, and may you have a wonderful new year if I don't get to work with you before the end of the year.
Thank you. Thank you, Maria. I hope you have a Merry Christmas and Happy New Year.
Thank you, Your Honor. May I
Bye-bye.
be excused?
Yes, ma'am.
Thank you.
Ms. Thompson, are you ready?
Yes, sir.
Tiffany Cooey. CR 22-208. Thompson, I show that we're set for docket call.
Yes, sir, but we've worked out an agreement and we'll set the plea.
Okay. All right, Ms. Cooey, I'm gonna have you raise your right hand so I can place you under oath. Ms. Cooey, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Okay, you can lower your hand. Ms. Cooey, I have in my hand a document entitled waiver of jury trial. Have you discussed this waiver of jury trial with your attorney, Ms. Thompson? Do you understand that you have the right to have your case tried before a jury of your peers? You understand that during that process, you have the right to confront the state's witnesses, cross-examine them, contest their evidence in front of that jury? You understand that no one can take that right away from you? The only way that that right can be deprived of you is if you say, Judge, I want to waive my right to a jury trial and I want to proceed in this case either by a plea agreement or a bench trial. Do you understand that? Has anyone threatened you, forced you, or pressured you to make you feel like you had to give up this right? And you're asking the court to allow you to waive your right to a jury trial and then continue in your case with a plea agreement. Is that right? Ms. Thompson, you discussed this waiver of jury trial with Ms. Cooey,
I have.
and you believe that she understands her right and what she's giving up.
She does.
Okay, all right, the court will find that Ms. Cooey has been admonished as to her right to a jury trial and that she has waived the same intentionally, knowingly, and voluntarily. The court is signing the waiver of jury trial this day. And we will set this matter for pre-trial. Is there any amount of time that's necessary? I'm sorry, what did I say? For pre-trial?
Yeah.
Is there any amount of time needed for money, or is this going to be a time for a plea for time, plea for probation,
Please turn.
plea for time? Okay. Ms. Thompson, are you available on Thursday, January 5th?
I believe that I am. Your Honor.
Okay, all right, court will set Ms. Cooey for January 5th. Ms. Cooey, we're gonna set that for 1:30. And you'll report out to the Van Zandt County Sheriff's Office, the Justice Center. They'll let you in, they'll bring you to the back and we'll do your hearing back there, and then they'll take you in a custody, okay? All right, we'll see you on January 5th.
Thank you, Your Honor. We have a good skill.
Yes, thank you, Ms. Thompson. It was a write-in. Yeah, it's you want to write it in at CR 22-208. Last name Cooey, Couey. First name Tiffany with a Y. It's possession, controlled substance, less than 1. And we're set 1/5/23 at 1:30.
Perfect.
Mr. Stevens, are you ready?
Yes, Your Honor, it'll be a plea on Mr. Chitty.
Michael Chitty, CR 22-267 and 308.
He's got 2 sets of papers, Judge. I put the probation conditions behind it.
Excellent, thank you for that. All right, Mr. Chitty, you'll raise your right hand, so I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So if you got, you can lower your hand, just speak up loudly and clearly for me. Your name is Michael Wilburn Chitty, is that correct?
Yes, sir.
Mr. Chitty, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with a mental condition?
Yes.
In this case, you're represented by your attorney, Mr. Bill Stevens. Are you pleased with him as your attorney?
Yes, sir.
Do you feel like you've had enough time to talk with him about your cases and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today with Mr. Stevens that you do not understand?
No, sir.
Mr. Stevens, do you believe your client to be competent?
Yes, sir.
And have you explained to him his rights as it pertained to each case and the plea agreements with specific regard to the advantages and disadvantages of a deferred adjudication plea?
Yes, I have.
And do you believe that he understands the rights and the important waivers he's making therein?
Yes, sir. I believe he does.
All right, Mr. Chitty, in one case, you are charged with possession of a controlled substance in penalty group 1 less than 1 gram. That is a state jail felony, and it does carry a range of punishment if convicted and sentenced of not less than 6 months in prison and not more than 2 years. and a fine not to exceed $10,000. In the other case, you're charged with driving while intoxicated, a second offense, which is a Class A misdemeanor, which carries a range of punishment of maximum up to 365 days or 1 year in the Van Zandt County Jail, and a fine which cannot exceed $4,000. Do you understand the range of punishment for each one of these cases?
Yes, sir.
Do you understand that there's a plea agreement in each case, and it appears to be that you would plead guilty to each charge, and on the felony case, it's recommended that your punishment, that a finding of guilt be deferred. That means that the court consider the evidence today, but not convict you of the offense, but defer a finding of guilt, place you on community supervision for a period of 2 years. You would pay a fine, restitution, court costs, reimbursement fees. The state would be dismissing a possession charge and a possession of marijuana case. You understand that to be the plea agreement in the felony case?
Yes, sir.
And you understand that the plea agreement in the misdemeanor case is that the state's recommending that you receive the maximum 1 year in the county jail, but that sentence be suspended and you being placed on community supervision for 1 year. In addition, you would pay a fine, court costs, and reimbursement fees. Is that your understanding of the plea agreement in the misdemeanor case?
That's correct.
Now, on the felony case, the issue with a deferred adjudication means that the court would defer a finding of guilt, not convict you, place you on community supervision for that period of 2 years. If during that period of 2 years, you were to violate any of the terms or conditions of your community supervision, the state would file a motion to adjudicate your guilt, meaning asking the court to convict you, and they could ask the court to revoke this sentence of community supervision and ask the court to assess punishment. And if the court found that you violated, the court could assess your punishment anywhere within that legal range, from the minimum 6 months all the way up to the maximum 2 years. And you understand that as well?
Yes, sir.
Understanding the range of punishment, understanding the plea agreements, do you still wish to go forward?
Yes, sir.
All right, Mr. Chitty, how do you plead to the state jail felony offense of possession of a controlled substance in penalty group 1 less than 1 gram?
Guilty.
And how do you plead to driving while intoxicated, second offense, a Class A misdemeanor?
Guilty.
Are you pleading guilty to each one of these crimes because you are guilty of committing each one of these crimes?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty to either?
No.
Court accepts the defendant's plea of guilt at this time. Mr. Stevens, any objection to the state's evidence?
No objection.
State's evidence is admitted in each case respectively, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor, we're resting close.
from the defense?
Resting close, Your Honor.
All right, court will review the evidence. All right, the court has reviewed the evidence. The court does find sufficient evidence to convict Mr. Chitty of each one of these offenses. The court will follow the plea agreement between the state and the defendant. Court hereby defers the finding of guilt in CR 22-267 on the charge of possession of controlled substance, penalty group 1 less than 1 gram. The court assesses punishment at 2 years community supervision. Orders Mr. Chitty to pay a $1,400 fine, $180 restitution, $290 court cost, $760 reimbursement fees, and the court dismisses DA 2021-843 and DA 2021-844 under section 1245 of the Texas Penal Code and cause number CR 22308. The court convicts Mr. Michael Chitty of driving while intoxicated, second offense, Class A misdemeanor. Assesses his punishment at 1 year confinement in the county jail. suspends that sentence, places Mr. Chitty on 1 year community supervision, orders him to pay a $100 fine, $270 court costs, $60 restitution, $35 reimbursement fees, and the court orders the sentence to run concurrent with cause number CR 22-267. Mr. Chitty, have you been on community supervision before?
Yes.
You have misdemeanor or felony? And did you successfully complete it or were you revoked? And what kind of charge was that?
I believe it was my first video, yeah.
Your first TWI? Do you have any felony convictions? No felony conviction? Do you understand that if you violate the terms of your community supervision, you would be looking at possible felony conviction?
Correct.
And you understand the damage that a felony conviction can do to one's life?
Yes.
You understand that it could affect your ability to support yourself and earn a living in a career?
That is correct.
So what's your plan on how to complete your community supervision?
Do everything that I'm.
Okay, and do you have a job?
Yes.
What do you do for a living?
I work full time at a senior HVAC technician.
Okay. How are you going to combat your drug problem?
I've been doing counseling in AA.
You married?
Divorce.
Divorced? Kids?
Yes.
Do they rely on you?
No, sir.
Are you
I mean,
involved?
Yes, but no.
What do you mean, yes, but no?
He's 17 years old.
17 years old? Do you think you're a role model for him?
Like, thanks, sir.
And is he on probation for drugs?
Yes.
Do you want him to be?
Yes,
Do you understand that you have a direct effect on whether he ends up on probation for drugs?
absolutely.
So you are a role model for him, whether you want to be or not,
Absolutely.
because he could be looking at you and deciding he's going to do what his dad does.
Yes.
All right. So I want you to think about that as you're doing your community supervision. Because if you don't want your son to be on probation for a felony offense, and you don't want your son to possibly go to prison, then I would think long and hard before I violated any term.
Absolutely.
All right. All right, Mr. Chitty, you're hereby remanded to the custody of the Van Zant County Probation Department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with Deputy Everett. And then the probation officers will give you more information. Well, I think I saw all of that. We'll find out. We'll have to give you that one. Yeah.
Man,
I didn't. I thought he was maybe trying to get my attention.
might be excused, Judge.
Yes, it's,
See you
Miss
this
Miss
afternoon.
Abraham says it's okay.
Oh, it was that one. Okay, we'll see you then.
Okay, yeah, he just came back in not long ago. Mr. Schmidt, are you ready?
Yes, sir.
Are you ready, answer?
Mr. Zarate.
Mr. Zarate? All right, this is cause number CR 21399, State versus Javier Zarate Jr. Mr. Zarate, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, lower your hand. Mr. Zarate, are you a United States citizen who reads, writes, and speaks English?
Yes.
And have you ever been diagnosed with a mental condition? In this case, you're represented by your attorney, Mr. Schmidt. Are you pleased with him as your attorney?
Yeah.
Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir.
And is there anything about the paperwork that you've read over and signed today that you do not understand?
No,
Mr. Schmidt, do you believe Mr. Zarate to be competent?
I do.
And have you explained to him his rights as they pertain to this case? And do you believe he understands the waivers of the rights that he's making herein?
Yes.
All right, Mr. Zarate, you are charged by indictment. You were charged by indictment with a first-degree felony offense of burglary of a habitation with intent to commit assault. However, it appears that the plea agreement in your case today is that the state's reducing that charge to a lesser included offense of assault causes bodily injury of a family member. Their recommendation is that upon your plea of guilty, that the court convicts you and assess your punishment at 5 days confinement in the county jail, with the court giving you credit for all 5 days of time served. You being ordered to pay a $1,200 fine, $270 court cost, and $585 in reimbursement fees. Is that your understanding of the plea agreement?
Yes.
All right, Mr. Zarate, how do you plead to assault causes? Well, let me tell you, the range of punishment for a Class A misdemeanor is confinement in the county jail for a period not to exceed 365 days and a fine that cannot exceed $4,000. So the court finds that the recommended sentence fits legally within the range of punishment for a Class A misdemeanor. Mr. Zarate, how do you plead to assault causes bodily injury of a family member?
Guilty.
Are you pleading guilty to that crime, Mr. Zarate, because you are guilty of committing that crime? And has anyone threatened, forced, or pressured you to plead guilty today?
No.
Court accepts the defendant's plea of guilt at this time. Mr. Schmidt, any objection to states one?
Judge, no objection to states one, however, we would state that, some of the conclusions in states one, we would dispute, and I think that's, forms the basis of the result of the plea here today, or entertain that, I think that's, at the end of the plea, explain what that is.
Okay, anything further from the state?
Yes, Your Honor, the state was convicted of compliant. We received no response to any of the communication.
Thank you, Ms. Heisel. All right, court's going to review the evidence. The court does take judicial notice of Mr. Zarate's judicial confession. All right, court has reviewed the evidence. The court finds sufficient evidence to convict Mr. Zarate of this offense. The court will follow the plea agreement between the state and the defendant. Do you feel the need for anything further, Mr. Schmidt? The court's not.
We don't, court wants it, we have to provide that information, but otherwise we're. Rest of the court.
It's up to you. I don't mind hearing you or Mr. Zarate out. I'm accepting the plea and follow the recommendation, but it may be important to your client.
For the record, I would briefly state that the original charge, the burglary element of the charge, we disputed initially. This was a family gathering. Mr. Zarate had permission to be in the residence and frequently did go to the residence with a family altercation. And obviously, we don't dispute the assault between him and a brother-in-law, but ultimately that's what led us here today. And I believe that that's fairly accurately depicted in stage one. I don't think that there's really any dispute except for the conclusion was as to whether or not he was in the residence without this.
Anything further from the state?
No, Your Honor.
Okay. All right, the court finds that there is sufficient evidence to convict Mr. Zarate. The court is going to follow the plea agreement in this case. Court hereby convicts Mr. Zarate of assault causes bodily injury of a family member. The court assesses his punishment at 5 days confinement in the county jail. Court awards Mr. Zarate 5 days credit towards his sentence for the time that he has already spent in jail. Court orders him to pay a $1,200 fine, $270 court cost, $585 in reimbursement fees. And Mr. Zarate, if you're not going to pay off all of the financial obligations that you owe to the county based on this plea, then I'm going to order you after the plea to go up to the court compliance officer on the third floor, meet with Ms. LaPrade and discuss with her setting up a payment plan so that we can get you paid off. Failure to comply with the payment plan will result in the court issuing a warrant for your arrest. You understand? All right, Mr. Zarate, you hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. Have you step over here with Deputy Everett to be fingerprinted? It's Ryan Solo. All right, you're Michael Edward Davis.
Sir.
All right, Mr. Davis, court has appointed Mr. Jonathan Manning as your attorney based on your application of indigency. Mr. Manning, have you had an opportunity to be provided with a copy of the indictment?
We have, Judge.
Are you ready to go forward on arraignment?
We are, Judge.
Go ahead, sir.
Judge, my client's name is spelled correctly in the indictment. He understands the charge against him. He understands the range of punishment. This time he's pleading not guilty on the quest he set on the pre-trial.
All right, court will find that Mr. Davis has waived the formal requirements of arraignment, will enter his plea of not guilty into the record, and will set this matter for pretrial hearing. Are you available February 7th, Mr. Manning?
Let me confirm. Judge, if I may have a ninth, that'll be Thursday.
Oh, I'm sorry. I had your days fixed up. All right, court sets Mr. Davis for pretrial hearing Thursday, February 9th. Well, I hope, Mr. Manning, that we'll be back in the courtroom upstairs, but if not, we'll let you know.
Yes, Judge.
And Mr. Davis, have you signed conditions of pretrial release?
Yes, sir.
They've met with you and you've gone over that. You understand what those are?
Yes, sir.
Thank you, sir. All right, make sure you stay in compliance with that, and we'll see you back on February 9th.
Sure, thank you.
And Judge, the only other case I have is Mr. Young's. My understanding is he's still in transit from Louisiana. I have something to hand up in jail, so if it's all right, I'll. run
Yes,
that
sir.
over. Mr. Young was gonna be just a reset, to have additional pretrial, I think some time to go over some potential contested issues, with him, at my office, discovery, so I was just gonna request some additional pretrial in his case. Do you want me to? I can leave a repeated reset form.
Have you discussed that with him?
I have not had an opportunity to discuss that with him at this point. I was
Yeah, well,
recently appointed and his arraignment was done by someone else.
okay, yeah, so I'd rather wait, and if he gets here, have you come back, if you don't mind, that way.
Absolutely.
You make that announcement, he'll understand that coming from you better than coming from me.
So,
But yeah, go ahead and handle your business at the jail. We'll let you know. If he doesn't show up, we'll let you know as well.
thank you.
Is your one? Oh. What about, Brian Willett? Brian Willett? With Mr. Laney? He's not here, right? Laney is, but his attorney's not right. You're gonna make my Christmas suit list, you know that, right? Did you see my post? Mr. Water, you ready, sir?
Yes.
Let's see. Any certain order you want to go in?
We could, start with Mr. Fletcher, please.
Fletcher. Sandra Fletcher. This is CR 22-272, State versus Sandra Gail Fletcher for docket call.
Your Honor. See Ms. Heisel in here, but she just ran with it. Ms. Heisel and I discussed this case, and we're still talking about some possible resolutions. I think both parties still like if we could have another reset, that maybe come to some agreement of some sort.
All right, court will find that this is Ms. Fletcher's first setting for docket call. Court will grant the defendant's request for an additional docket call setting. Mr. White, I have a couple dates in January. I got that January 24th. I got a January 5th, 24th, or February 7th.
Your Honor, Ms. Fletcher has a surgery scheduled for.
It's injections in my.
Okay, she's got injections in her hand.
You want to do court before that or after that?
We can do that after I do that.
February 7th.
Thank you, sir.
All right, Ms. Fletcher, court orders you back on February 7th at 9 a.m.
Your Honor, it's Ms.
Yeah, she's free to go.
Thank you.
Be ready on your next one.
Ms. Robinson.
Robinson. Mary Lynn Robinson, CR 22-194. Mr. Robinson set for pretrial.
Your Honor, I have filed some pretrial motions in this. I believe the state has addressed those from the, Mr. Woodwife uploaded the major crash investigation report onto the portal. I spoke with Mr. Woodwife, about this. I had asked about the, so-called, the data recorder that was in the alleged victim's vehicle. And my understanding that there is no data recorder. Is that correct, Mr. Woodwife?
That's my understanding.
And Your Honor, as far as I wanted the standard operating procedure, manual from the DPS now, I don't believe Mr. Woodwife and I have directly addressed that. I did actually talk to Trooper Cosper about it, and he wanted me to know that I can get it online, which, Your Honor, I am aware that I can get it online. And I believe the state would take the position, I hope they would, that the same one that Mr. or Trooper Cosper did, which was if I bring up anything out of that manual, if I got it online, they're not going to say that's not my manual. So if I can get it online, I'm okay. Otherwise, I won't even provide it to you. But I have, we can sort of address that. It's not like I can't get it. I just don't want to be in a position where we're in front of a jury and possibly, and I start bringing up things and I'm told that that is my manual. And then we have to stop down and have everybody read it. So.
State's not sure how to respond to that, Your Honor. I have no doubt if the defense wants to provide the relevant portions that they would like, if and when that it comes to that, if the defense wants to provide whatever portions of the manual that they find relevant, we can bring them to the trooper's attention, have them pre-review and make sure that that is from the current version of the standard operating procedure. And then we can avoid the issues that he is possibly anticipating.
Judge, this won't hinder my trial preparation at all. If we can't come to an agreement, I'm sure we'll come to you and complain about it.
Okay.
All right.
Are we ready to move forward to docket call then,
Yes.
or? So there's no contested pretrial motions other than maybe some, though that issue regarding.
And as far as the dictates of the standing order regarding 702 objections and those things, but I don't believe the state is required at this point to declare the expert yet. So, but that would be something like we've done in our other cases when we're aware of it. All about it.
Okay. All right, the court will set this case for docket call on February 7th. That'll be at 9 a.m. Hopefully we'll be back in our usual courtroom. If not, we'll let y'all know. Yes, you're free to go, Ms. Robinson. Thank you.
Your Honor, we have CR 22-278. The state's provided me a copy of the motion dismissed down tender into the court.
Joshua Martin, CR 22-278. All right, Mr. Martin, the state has tendered a motion to dismiss at the request of the complainant in this case. Court will grant the motion and sign the order of dismissal. You're free to go, sir.
Thank you.
You ready on your pleas with Mr. Valderrama and Mr. Rosser?
Yes, sir. Let's.
This is cause number CR 22-256, State of Texas versus George Valderrama. Mr. Valderrama, if you'll raise your right hand, sir, I'm going to place you on oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth and nothing but the truth, so help you God? All right, you can lower your hand. All right, Mr. Valderrama. Are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with a mental condition?
Yes, sir.
You're represented today by Mr. White. Are you pleased with him as your attorney?
Sir.
Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Sir.
Is there anything about the paperwork that you read over today with Mr. White that you do not understand?
Yes, sir.
Mr. White, do you believe Mr. Valderrama is competent today, and have you explained to him his rights as they pertain to this case and also the advantages and disadvantages of a deferred adjudication plea?
Your Honor, I believe he's been competent, and I believe his waiver should be executed knowing the intelligence and voluntarily, and I have gone over the advantages and disadvantages of deferred adjudication. I believe that he understands the consequences of entering into such a plea.
All right, I'm a little bit, let's see, confused here. So the judgment says it's charged by information, but I have an indictment in this case. Is there,
I didn't catch that, but
so the judgment just needs to be changed. So he was properly indicted by the grand jury.
Judge, just for the court's record, this was presented for indictment in the July session of this year.
Yeah, I've got the indictment.
Oh, yeah.
Okay. Can you all get me a new judgment that says indictment thing?
Change that.
Thanks, sir. All right, Mr. Valderrama, you've been indicted with a state jail felony offense of possession of a controlled substance of penalty group 2 less than 1 gram. That carries a range of punishment of not less than 6 months in prison or more than 2 years in prison, and a fine not to exceed $10,000. I see here that the plea agreement in your case is that upon your plea of guilty, the state's recommending to the court that the court defer a finding of guilt. That means not convict you of this offense, but rather place you on community supervision for 2 years. And if you successfully complete that community supervision, the case would be dismissed. If, on the other hand, you do not successfully complete your community supervision, the state could file a motion to adjudicate your guilt. That means to convict you. And they could ask the court to revoke your community supervision and ask the court to sentence you to prison at any rate between that minimum 6 months all the way up to that maximum 2 years in prison. Do you understand that?
Sure.
You also, as a part of your plea agreement, would have to pay a $1,000 fine, court costs, restitution, reimbursement fees. And you've read all of that with your attorney, Mr. White, right? Understanding all of those things, do you still wish to go forward?
Yes, sir.
All right, then, Mr. Valderrama, I ask you, how do you plead to possession of a controlled substance of penalty group 2 in an amount less than 1 gram? And are you pleading guilty to that crime, Mr. Valderrama, because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty? All right, the court accepts the defendant's plea of guilt. Mr. White, any objection to the state's evidence?
no objection.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Judge, probation is sending me text messages, just if we could get Mr. Valderrama as a resident of the state of Louisiana, is that correct? How long have you lived in Louisiana? 5 years. 5 years, okay. Likely, this is an interstate compact case that we have no objection. State, the DA's office has no objection to transferring his probation to Louisiana. We would ask that, obviously, with recommendation probation, that process be commenced.
Do we need to stop and go through that to make sure that he's going to comply before we do it? Make sure that he has a residence, and these things.
Address on my driving license on my head. Just recently got a new place. Transfer house to an apartment.
Yeah, come over here and see Ms. Burns. Let her check through that.
But this is my license of my more. Big house to an apartment, so they don't have to. You know, man. I have to renew my license. Well, I got on. Yeah, everything I did. Put it on, say, you do it like a girl.
Yeah. Why is this a sanction on you? Let me step back. All right, we're back on the record, CR 22-256. Anything further from the defense, Mr. White?
No,
Okay. All right, court's going to review the evidence.
Remember, check the board.
All right, the court has reviewed the evidence. The court finds that there is sufficient evidence to convict Mr. Valderrama of this offense. Court will follow the plea agreement in this case. Court hereby defers a finding of guilt, places Mr. Valderrama on 2 years community supervision, orders him to pay a $1,000 fine, $180 restitution, $290 court cost, $35 reimbursement fee. Court dismisses DA 2022-0276, possession of marijuana less than 2 ounces. DA 2022-0275, possession of controlled substance penalty group 3, less than 28 grams. All right, Mr. Valderrama, you hereby remanded to the custody of the Van Zant County Probation Department so they can carry out the terms and conditions of the sentence. I'm gonna have you be fingerprinted by the bailiff, and then the probation officers will give you more information, okay? You go, Miss Taberham, she's gonna take you outside to be fingerprinted. Mr. Rosser. All right, Mr. Rosser, if you'll raise your right hand. Are you Isaiah Javier Rosser? So. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so be that? Yes, sir. Virginia. Sorry, Mr. Watt, the podium in here is not as beefy as what you're accustomed to upstairs, I'm sure.
Well, I just want that's all.
I know, upstairs. All right, Mr. Rosser, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with a mental condition?
Yes.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with him as your attorney?
Yes.
Do you feel like you've had enough time to talk with him about your case and have all your legal questions answered?
Yes.
Is there anything about the paperwork that you've read over and that you signed today that you do not understand? Mr. White, do you believe Mr. Rosser to be competent, and also have you explained to him his rights as they pertain to this case and the advantages and disadvantages of a deferred adjudication plea?
Absolutely, Mr. Ross, he's no competent. He waived his rights and does it voluntarily, and then he understands the consequences of the plea and
Thank you, Mr. White. Mr. Rosser, you are charged by indictment with a second-degree felony offense of possession of controlled substance in penalty group 2 in an amount greater than or equal to 4 grams, but less than 400 grams. That is a second-degree felony and does carry a range of punishment if convicted and sentenced to not less than 2 years in prison or more than a maximum 20 years in prison and a fine not to exceed $10,000. Do you understand that if the court approves this plea agreement today, which the state's recommending that the court defer a finding of guilt and place you on 3 years of community supervision in addition to your fines and court costs and the state dismissing some cases to go along with it? You understand that if while you're on probation, if you violate any of those terms, the state could file a motion, bring you back before the court, you could have a hearing. State proves to the court that you violated, the court could adjudicate your guilt, that means convict you, and the court could revoke your community supervision and could sentence you to prison anywhere between the minimum 2 years to the maximum 20 years. Understanding those things, do you still wish to go forward? The court then asked Mr. Rosser, how do you plead to that offense? Are you pleading guilty to that crime because you are guilty of committing that crime? Has anyone threatened you, forced you, or pressured you to plead guilty? Court accepts the defendant's plea of guilt. Mr. White, any objection to the state's evidence?
No objection.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor,
From the defense? All right, court's going to review the evidence. I guess one element of this plea that I failed to see is on page 2, is that you're agreeing to the forfeiture of the Glock model 21 semi-auto 45 that was seized in this arrest. Is that correct?
Yes, sir.
Okay.
Judge, and that stems from the associated cases in the paper.
Okay. Are the associated cases stemming from the same fact pattern?
They're all this, it's all the same.
Okay. All right, the court has reviewed the evidence and the court does find sufficient evidence to convict Mr. Rosser of this offense. Court will follow the plea agreement between the state and the defense. Court hereby defers a finding of guilt, places Mr. Rosser on 3 years community supervision, orders him to pay a $2,500 fine, $290 court cost, $35 reimbursement fees, $180 restitution. And the court dismisses under section 1245 DA 2021-248 possession of marijuana and DA 2021-0247 unlawful carrying of a weapon. And the court will order the weapon forfeiture in this matter. Mr. Rosser, how old are you?
21, just turned 21.
Just turned 21. You're a young man.
So,
What do you hope to do in your future?
I plan on on my own business. Try to raise some money on my own passion business.
Okay. Do you know that having a felony conviction and after going to prison would make that very difficult?
So,
Have you ever been on probation before?
myself.
You understand that sometimes the public perceives probation as being a slap on the wrist and something that's very easy to comply with. Do you know that it's actually much harder to be on probation than it is to be in jail or prison? Did you know that?
Yes, sir.
And the reason I think that is because probation requires people to be accountable, to be responsible, to be driven to do what it is that they need to do to stay out of prison. Whereas people in prison are told what to wear, what to eat, when to go to the bathroom and when to go to sleep, like a child, right? So probation is actually much harder, and it takes a responsible adult to be able to handle these responsibilities. And so you're telling me that you know what these responsibilities are and that you're going to take them on, understanding what the consequences are if you don't, right?
So,
All right, Mr. Rosser. Court hereby remains you to the custody of the probation department so that they can carry out the terms and conditions of the sentence. I'm gonna have you go with Ms. Taberham. The bailiff is going to fingerprint you, and then these probation officers will give you more information, okay?
John, we had a case set this afternoon on Mr. Downs. The plea agreement, you want to go ahead and write it in, so it's going to be for 9 months in the state jail. It's got 305-day credit.
I mean, there's
305. There's going to be no fine. And,
290 court costs.
yes, and
Any restitution?
there's going to be 20,575.45.
It's a 9-month state jail, 305 credit, 290 court costs, 20,575.45 restitution.
Yes, sir.
Let's see, 1245s.
No, sir.
Okay.
He's already doing. He got 6 out of Johnson. It's just. So.
All right. Mr. Evans, okay, yeah, will you text him or whatever? Thank you. Yeah, Mr. Willett. Mr. Laney,
Yes, sir.
Mr. Willett gonna be here?
He's supposed to be.
Yeah.
You didn't tell him last time we were here to be here, so I don't understand
Okay,
why he missed that.
do you want to step out in the hallway and call his office? Oh, you've already done that? Any response?
And, you know, more of his office is still trying to get a hold of the actual legal team to make sure that they understand that he's supposed to be here. I don't
Okay.
understand why it's just today.
Okay. Well, you're here. That's the good news.
Yes, sir.
All right. So, Mr. Carroll. All right, this is in cause number CR 21208. This is Bryce Christopher Carroll, sanctions court hearing. All right, Mr. Carroll, at the last hearing we had, I set out some sanctions that you needed to comply with, and it appears that you've met the condition to pay your probation. You did that. You met your condition to pay with your court collection. You did that, and you met your community service hours. The only thing that I don't have is your certificate or proof that you did your substance abuse evaluation. Ms. Burns tells me that you have done that. You just don't have proof of it. Is that correct? Okay. How quickly can you get that?
I don't know.
No, that's okay. I mean, you're just going to need to get some kind of confirmation from them so that you can turn it into your probation officer so they can show that you've complied with it. Okay. So what we're going to do is I'm going to reset you for January 24th. When was our last? Okay. All right. So Mr. Carroll, I'm going to set you for January 24th. It'll be at 9 a.m. And I need the same things. You need to pay 65 to your probation, 85 to your court collections. You need to do your 10 hours community service, just like what you did this last month. And I need you to bring confirmation that you've done your substance abuse evaluation. Once we get a couple months in a row showing that you're meeting all of your requirements, I'll get you out of sanctions court and you can go back to being on regular probation and not have to come to court. Okay. So what we're looking for is a pattern. You get, 3 months. If you can do this 2 more times, I'm sure the probation department's going to say, okay, Mr. Carroll's complying with everything. Take him off the court docket and let you just stay on regular probation like you've been doing. Okay. So that's what we're looking for. So we're going to give you this notice of appearance, come back on that date, do all those things again, and you'll be one step closer to having me out of your life. Okay. I know you think that's a good thing. It probably is. And it is a good thing. It is a good thing. It's not going to hurt my feelings. All right. We'll see you back on the 24th.
Right.
Where's that?
Where is he at? Which course he at?
I should verify that. I should verify that. Is this on Mr. Davis? Michael Davis.
Oh, we're gonna do my.
Oh, I'm sorry, not Michael Davis.
This is Mr. Young.
Yeah, yes, I'm sorry. Mr. Young, CR 22-349. Mr. Young is set for pretrial.
Yes, Judge. I would request. Per our request earlier, there are some items I'd like to go over, Mr. Young. I believe there's be some test issues that arise out of the stop, some of the evidence and statements that were seized. And so we request a additional setting to see if that motion stress is necessary. I'd ask that we set out February as Mr. Young is coming from a long distance. We're coordinating a meeting at our office with both him and his co-defendant. And so we request that it be like a little more time just so I can get everybody on the right page.
February 9th.
That was Judge.
All right, court sets Mr. Young for February 9th at 9 AM. For pretrial. Mr. Young, if you'll check in with Mr. Waddell, the pretrial release officer, before you leave, then you're free to go, okay? We'll let him know you're out there. I mean, I don't have any issues. I just want you to check in with us. Hey, Rachel, will you let Carl know that he's out there, and I'll just ask him to stick around until he meets your call. Mr. Sanders, are you ready with Ms. McInnis?
Yes, Judge, I am.
Ms. McInnis, come on up. CR 21-153, 156, and 179. Tyler Elizabeth McInnis, and we are set for docket call. Mr. Sanders.
Yes, Judge, and that will be a plea. We could just reset these for a plea hearing. I was hoping that maybe we could do it today, but I didn't get in touch with the DA's office early enough yesterday to get the plea papers done, so.
Is it a plea for probation or time?
Probation. So sometime in January,
Got January 5th.
yes, I think that should be fine.
Okay. All right, court sets Ms. McInnis for plea on January 5th. And I think on that day, we should be across the hall in the county court, Mr. Sanders.
Okay, okay.
All right, Ms. McInnis, once you sign and get your yellow copy, you're free to go.
Thank you.
You're welcome. Did Mr. Willett say, or his office say how long it would be before he got on to?
Or get out.
All right. Court will stand in recess until Mr. Willett gets on for Mr. Laney. He'll appear via Zoom. And we're also waiting to see if Miss Mota, who's called the court, said that she thought it was at 1:30 and said that she was on her way. So we'll see if she appears. And then, yes, we have an 11 o'clock. So we'll stand in recess for about 15 minutes. Now, is Mr. Let's see. This, I guess, and Mr. Adams, so Mr. Adams and Mr. Hawkins are both ill. Yeah, okay. All right, we'll stand in recess for 14 minutes.
Actually,
Mr. Hawkins, Mr. Sanders, either one of you ready? So CR 22-352, State versus Randa Nicole Boaz. Ms. Boaz is set for pretrial today.
Your Honor, we are asking for a pass judge. We had a video audio issue that needs to be looked into. There's a portion on the video that and I've talked to the prosecutor on the case, Hillary, and she's gonna look into it and see if it's related and also if it's just a video itself.
Judge, that's correct. We talked to Mr. Hawkins about dates. We're not opposed to sending this out to February 7th, just to give us time to look into that. Based on my review of the case, the video he's describing, I don't even know is associated in this case, but if it is, there are audio issues. I'm gonna get another copy. So it probably will take a little longer to work that issue out.
Okay. All right, court will reset Ms. Boaz for February 7th for pretrial. Hopefully, we'll be back in our courtroom upstairs. If not, we'll let you know.
What time is that on the day, Judge?
9 o'clock.
Sure. I think you know.
Yes, taking shots. Mr. Adams, ready on Mr. Nash?
I don't know. They're gonna play. They got pretty long. Yeah.
Yeah, we just haven't seen him, so.
You still don't see Mr. Miller.
No.
The motto's on the way. I don't know if she's Dr. Richard.
She on her way up or way down?
He said confused. She was, exactly.
Who said that?
Richard. I don't know if she's Dr. Richard's office.
Richard doesn't represent, right?
No, our Richard was at the jail. I don't know.
Why was she talking to Richard? She's trying to hire Richard?
No, he said no.
He said, no, she's not trying to hire.
He said, just sent one over, not my client, because that when your notice said 1:30. I said, yes, she was in jail on the day. He said, confused, she was.
And then Carl's Thursday, we told her.
Carl told me?
That's what he called. So now that was 15 minutes ago, and not that far from Richards.
Now she's confused which court. She may be over at all.
You may. All right, we are on the record. This is State versus William Laney the fourth, and we are set for pretrial today. Mr. Willett, have you received your discovery? Are there any contested pretrial issues? And you'll have to unmute your device. You're gonna have to unmute your device. No, you're still on mute.
Now,
All right, do you have any contested pretrial issues, pretrial motions that need hearing, or any issues with discovery?
no, Your Honor, I received all discovery now.
Okay, and so you're ready for the court to place it on docket calls so that you can discuss with your client whether or not this is going to result in a plea agreement or a trial?
Your Honor, I've actually spoken to him and he does want a trial in this case. So if you want to put it to that, we can even do that.
So y'all do not want to engage in any negotiations with the state?
No, I've spoken to him and he wants a trial on the case.
That's true, Mr. Lamy?
Yes.
Okay, all right, and you understand, Mr. Lamy, that if I put it on the jury selection docket, later you change your mind, the court's not going to entertain plea bargaining because you waived that period.
Yeah, I understand.
Okay. All right, so the court will find that there are no contested pretrial issues, that the defendant has asked to be placed on the jury selection docket. And the court is bypassing the docket call announcement at the request of the defendant, who has had the advice of counsel. And the defendant has been admonished that the court will not entertain a plea agreement after today. All right, the court will place Mr. Lamy on the court's jury selection docket. Mr. Lamy, we'll begin that on Monday, January 30th. So what you'll do is you'll just report to the courthouse on that day around 8:30, and Ms. Taberham or another member of my staff will be here. Your case will not be picked for trial that day. You will enter onto the court's trial list, and you'll continue to appear and get reset until your case reaches the top 10. Once the case reaches the top 10 of the course list, then Mr. Willett will be notified, and then both you and Mr. Willett will have to be there on that day. Mr. Willett will not be there in all the other times unless he so chooses, okay?
Okay.
All right, so we'll see you on January 30th. Make sure you stay in contact with your pretrial supervision officer.
All right, thank you.
Thank you, Mr. Willett.
Thank you.
Okay, so they are going to plead. Mhm. Mhm. That makes sense.
This will be an amended MTA. This is about to revoke. It'll be an amended MTA. It's not gonna be regular. Whatever you call it.
Yeah.
We're just amending it, so I guess you can still use it.
Yeah, I'm just trying to get the warrants.
Well, on amended MTA, there's not. Well, we're not going to- So we're just amending.
Yeah, I see what you're saying. I'm not gonna say that I'm gonna build it. Not have it. Yeah, that makes sense. Yes, so Patty. Yeah, go ahead and give me a balance situation. And then I'll respond about it and go check. She's done all this already. It's all good, but she's on. And I would bear a position because of that. Now.
No, we are.
Right, but I'm saying we're not, they're not electing, they're on. I'm just gonna do it. We'll figure it out. Mr. Nash, you ready? Come on up. See what I'm saying? Yeah, I'm gonna do it anyway. All right, this is cause number CR 2271, State versus Kenneth Ray Nash Jr. Mr. Nash, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Okay, you can lower your hand. All right, Mr. Nash, are you a United States citizen who reads, writes, and speaks English?
Yes.
And have you ever been diagnosed with a mental condition? In this case, you're represented by your attorney, Mr. Mitch Adams. Are you pleased with his representation of you? Do you feel like you've had enough time to talk with him about your case to the point you've had all your legal questions answered? Is there anything about the paperwork that you've read and signed today that you do not understand? Mr. Adams, have you explained to Mr. Nash his rights as they pertain to this case and also the advantages and disadvantages of a deferred adjudication plea?
I have, Your Honor.
And do you believe that he understands them?
I believe he does.
All right, Mr. Nash, it appears here that you were charged by indictment with a first-degree felony offense of aggravated sexual assault of a child, but the plea agreement being presented to the court is that you would plead guilty to a lesser included offense of injury to a child, a third-degree felony offense, with the state recommending to the court that a finding of guilt be deferred and you be placed on 10 years community supervision with a $2,500 fine. Is that correct? Ms. Mota, I need you to be quiet. Is that your understanding of the plea agreement? All right, so Mr. Nash, the range of punishment for a third-degree felony offense, injury to a child, if convicted and sentenced, would be for a period of not less than 2 years in prison to a maximum 10 years in prison and a fine not to exceed $10,000. Meaning, if the court accepts this plea agreement and places you on community supervision, that if you violate any of the conditions of your community supervision, the state can file a motion to adjudicate your guilt, bring you back before the court. If they prove to the court that you violated, they could ask the court to convict you, revoke your community supervision, and ask the court to assess your punishment anywhere between the minimum 2 years to the maximum 10 years. Do you understand that? Understanding all of those things, do you still wish to go forward? All right, then Mr. Nash, how do you plead to injury to a child? Are you pleading guilty to that crime because you are guilty of committing that crime? Say again? Did you say yes? You said no? You're.
Not her, you're-
Because it's pleaded. It's an. Guilty because.
Are you pleading guilty because you committed a crime of injury to a child? Okay, counsel, I'm not sure I'm understanding.
Could we recess and go in chambers for a couple of minutes?
Yes, but we're gonna adjourn for lunch at noon, so we're gonna be on a tight schedule.
Oh, I'm off for that.
Okay, yes.
Supposed to do that.
No, go ahead. Look, I'll give Mr. Adams a few minutes to talk with you about what the court has to do in its admonishment. So go ahead and take a few minutes. And if you need to step outside, Mr. Adams, you got plenty of time. No, that brings up a point. All right, Mr. Adams, we ready to proceed? Okay, so let's go back over this, Mr. Nash. So I told you what you were originally indicted for. I've gone over what the plea agreement is. And so what the court has to know is, are you pleading guilty to injury to a child because you are guilty of committing that crime? And what I have to make sure is that you're not pleading guilty just so you can get this plea agreement. I have to actually hear you say that you are pleading guilty to this crime because you are in fact guilty of this crime, injury to a child. So I'll ask you again, how do you plead to injury to a child, a third-degree felony? And you are pleading guilty to that crime because you are guilty of committing that crime.
Yes.
Has anyone threatened you, forced you, or pressured you to plead guilty to this crime? Court will accept the defendant's plea of guilt at this time. Mr. Adams, any objection to the state's evidence?
No objection, Your Honor.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Sure, state is in compliance with victim notification. We have nothing to present to the court this time.
All right, so no response from the victim as far as an agreement or disagreement?
Correct, Your Honor. We received no response back one way or the other.
Anything further from the defense?
Your Honor, if I might briefly take the client on for a little bit of testimony.
Yes, sir, go ahead.
Would you state your name for the record for us?
And make sure you speak up so my court reporter can take it down.
Mr. Nash, you understand the plea agreement that we've entered into or that we're going to enter into today?
Yes, sir.
And you understand that you're going to be on probation for 10 years for that?
Yes, sir.
And you understand that you won't be found guilty of anything today?
Yes, sir.
And that when you finish upon successfully completing your probation, whether it's after 10 years or released from it early, you will not have a final conviction on your record. Is that right? Yes, sir. Now, yesterday, when you were in my office, talking about this, we discussed deferred adjudication, probation, and what it meant, what the carrot is, what the stick is. Is that right? Now, in doing so yesterday, I represented to you that after successfully completing deferred adjudication probation, you can petition the court for something called an order of non-disclosure. You recall us talking about that yesterday? Yes, sir. And in going through the paperwork today, I realized that I was mistaken in making that representation to you, that by law, it would not be legal for this court to grant a petition, an order of non-disclosure after successfully completing a deferred adjudication probation in this case. Is that right? Yes. And I've discovered that mistake, that error of mine, as we were going through the plea paperwork about a half an hour ago. Is that right? Yes, sir. And it is your intent, nevertheless, to go forward here today and enter the plea of guilty in exchange for the state's plea recommendation, even though you would not be eligible to obtain an order of non-disclosure when you're finished with the probation. Yes, sir. Okay. In the stipulation of evidence, Mr. Nash, you had a question of me insofar as the language in the stipulation says that you are entering
a guilty plea to the offense charge. The offense charge is aggravated sexual assault of a child. I explained to you that, for lack of a better way to put it, the language in the stipulation of evidence is boilerplate. And if we were going to split hairs, that document should read that you are agreeing to enter a plea of guilty to the lesser included offense that you pled to today. Is that right? Yes, sir. Okay. You understand that if we went to a jury, if we had a jury trial, a jury could potentially find you not guilty, right? And you understand that if we had a jury trial, the jury could find you guilty, and that the minimum range of punishment would be 5 years in the penitentiary. So you understand it? And that you would not be eligible for probation in those circumstances. Is that your understanding? Yes. Okay, I'll pass the witness.
State,
Stay on it.
anything further, Mr. Adams?
Nothing further on the rest of clause.
All right, court has reviewed the evidence and the court finds that there is sufficient evidence to convict Mr. Nash of this offense. And so state this is your recommendation on behalf of the prosecution and representation of the victim for the court to accept this plea, correct? Sure. All right, the court will follow the plea agreement. In this case, the court hereby defers a finding of guilt for the third-degree felony charge of injury to a child. The court places Mr. Nash on community supervision for a period of 10 years. The court orders him to pay a $2,500 fine, $290 court costs, orders him to pay reimbursement fees of $1,285. All right, Mr. Nash, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you go with Ms. Tabor. She's gonna take you outside to be fingerprinted with the deputy, and then you'll see the probation officers from the information.
You do it. Staying on that. Yeah, that's a good plan. One.
There we go. I put this on right there. All right, and cause number CR 22-113, State versus Alejandra Mota. The court called Miss Mota's name at 9 a.m. She was not present at that time as ordered. The court then received communication that Miss Mota was en route to the court, believing that her court hearing was at 1:30. Miss Mota did appear. Court has ordered her to undergo urinalysis testing. Miss Mota had indicated that she would be unable to provide a specimen. And as she was waiting in the courthouse, law enforcement believed that she was attempting to abscond from the court. And so the court has found that Miss Mota did not appear in court as ordered at 9 a.m. Therefore, is going to, in addition to her failing to provide the specimen when requested, the court is finding her bail to be insufficient at this time. The court has ordered her into custody and has issued a new bail at $250,000. We will set Miss Mota for January 5th. And I'll ask that you see if Miss Mota is going to be claiming indigency and needing court-appointed counsel. And she does have, I believe, does she have a motion to adjudicate pending? She has one motion to adjudicate pending, may have an amended copy. So we'll set that for January 5th. So we'll do attorney status.
Just as her was with him, has Richard Schmidt. So just FYI, I don't know if that would create a conflict or not.
You know, what was he being retained? Did he ever say?
He was on somebody else.
Oh,
All right, I believe that does conclude this morning's docket. Or we'll stand in recess till 1:30.
so we're sending permission to remove.